Good morning, the Honorable Dean of Law Faculty of Hasanuddin University, Professor Dr. Hamzah Halim, SHMH MAP, the Honorable Professor Stefan Koos from Universität der Bundeswehr München, Germany. Welcome back to Hasanuddin University. The Honorable Vice Dean of Planning, Resources, and Alumni, Professor Dr. Iin Karita Sakarina, SHMA. The Honorable Vice Dean of Partnership, Research, and Innovation, Dr. Ratnawati, SHMH. The Honorable Head of International Cooperations, Dr. Birka Latif, SHLLM. The Honorable Head of Study Programs, Professors and Lecturers of Law Faculty Hasanuddin University, and dear participants. Assalamualaikum warahmatullahi wabarakatuh. And good morning. My name is Fadila, and it's an honor for me to host in the special occasions of MOA signing ceremony between Hasanuddin University and Universität der Bundeswehr München, Germany. For the first agenda of the signing ceremony, I would like to invite the Dean of Law Faculty of Hasanuddin University, Professor Dr. Hamzah Halim, SHMH-MAP, to come to the front to sign the memorandum of agreement along with Professor Dr. Stefan Koos, please. So for the first document, the document that will be signed is the memorandum of agreement between Law Faculty of Hasanuddin University and Universität der Bundeswehr, München, Germany. Thank you so much, Dean. Oh, and for the okay. As a token of appreciation for the cooperations between as a token of appreciation for the cooperations between Hasanuddin University and Universität der Bundeswehr München, I would like to invite the Dean of Law Faculty as well as Prof. Stefan Koos. Semua ini. So this is with the signing of implementation agreement by the head of the study program of the legal study program, Dr. Putra. And next will be the signing of implementations agreement between the head of administrative law program in undergraduate level with Universität der Bundeswehr München, Germany. We show the agreement for the teachers. Now I would like to invite Professor Dr. Marwati Risa as the head of Legal Studies program in doctoral level to please come up to the front to sign the implementations agreement. So the implementations agreement is signed by all the head of study programs, either in doctoral programs, postgraduate program, and also undergraduate program with total of 5 study programs. And this will be the last implementations agreement to be signed. This will be the signing of implementations agreement between the Universität der Bundeswehr München and notarial programs and also legal study program in postgraduate level. Now, as a token of appreciations, the Dean of Law Faculty, Professor Dr. Hamza Halim, would like to give the token of appreciations to Professor Stefan Koos. And as a return, Professor Stephen Koos would also like to give a token of appreciations in the form of book to our Dean of Law Faculty, Hasanuddin University. This is a book that directly written by the Professor Stephen Koos. Thank you, everyone. You may please be seated again. In these occasions, I would like to invite the Dean of Law Faculty of Hasanuddin University, Professor Dr. Hamsa Halim, to deliver his welcome remarks.
Thank you, MC. The Honorable Professor Dr. Stefan Koos from the Universität der Bundeswehr München, Germany. Thank you for your coming in Faculty of Law. The Honorable Vice Dean of Learning Resource and Alumni, Professor Dr. in Karita Sakarina, SHMA. The Honorable Vice Dean of Partnership, Research and Innovation, Dr. Ratnawati, SHMA. The Honorable Head of International Law Department and Head of International Cooperation, Dr. Birka Latif, SHMH LLM. The Honorable Secretary of the Quality Insurance and Reputation Enhancement, Dr. Marwah, SHMH. Please stand up. Thank you. The Honorable Head and Secretary of Department, Head of Study Program and Lectures within the Faculty of Law Hasanuddin University. Assalamualaikum warahmatullahi wabarakatuh and good morning. It is and for the Law Faculty of Hasanuddin University, welcome Professor Stefan Koos from the Universität der Bundeswehr, München, Germany, to our beloved campus. On this special occasion, we are grateful that Prof. Stefan Koos is able and willing to share his knowledge in today's student general and the topic challenge for the law in the digital globalization, relation between technology, sovereignty, and law. Many of you have allocated your time in this Tuesday to be here, sir, as a reminder to us all just how important our work is to boost global awareness on the issues of digital globalization, relation between technology, sovereignty, and law. Faculty of Law Hasanuddin University, as one of the law faculty in Indonesia, which is playing an important role in sharing these challenges. As a dean of the Faculty of Law, I sincerely hope that this collaboration can be continued and bring significant benefit to our campus. My hope is that in the future, our collaboration will become closer in other innovation programs and strengthen the relationship between the Faculty of Law, Hasanuddin University, and the Faculty of Law, Universität der Bundeswehr München, Germany. Thank you very much, and by the end of this speech, I hereby officially open this student general. Thank you. Wassalamualaikum warahmatullahi wabarakatuh, and good morning.
Thank you so much, our Dean, Professor Dr. Hamsa Halim, for the welcoming speech. That's the end of the signing ceremony. Now we are going to proceed to the Stadium Generale by Professor Stefan Koos with theme Challenge for the Law in Digital Globalization, Relations between Technology, Sovereignty, and Law. These sessions will be led by our moderator, Dr. Kadarudin, as also the Secretary of International Law Department. Therefore, I would like to invite our beloved moderators to come to the front to lead the session.
Thank you, Bu Fadilah. Assalamualaikum warahmatullahi wabarakatuh. Good morning. The Honorable Dean of the Faculty of Law, Hasanuddin University, Professor Dr. Hamzah Halim, SH, MH, MAP. The Honorable Professor Dr. Stefan Koos from the Universität der Bundeswehr München. Sorry if my spelling is wrong. I learned the pronunciation last night using Google Translate, but there might still be mistake. As a speaker for this session, the Honorable Vice Dean of Planning, Resource, and Alumni, Professor Dr. Iin Karita Sakarina, SHMA, the Honorable Head of International Law Department and Head of International Cooperation, Dr. Birkah Latif, SH, MH, LLM, the Honorable Secretary of the Quality Assurance and Reputation Enhancement, Dr. Marwah, SH, MH, the Honorable Heads and Secretaries of Departments, Heads of Study Programs, and lectures within the Faculty of Law, Hasanuddin University. My respectable audience of this Stadium Generale, the fact that many of you have allocated your time this Thursday to be here, as stated by Dean Hamzah at the opening of the event, serve as a reminder to us all just how important our work here is to bridge global awareness on the issues of digital globalization, relation between technology, sovereignty, and law. This moment is happy for me because I can meet all of you in this session, both offline and online. Many questions about digital globalization. How does digital technologies affect globalization? What are the advantages of digital globalization? And why is there a digital divide in globalization? Even yesterday, I had a conversation with Professor Stefan Koos, and he said that it turned out that the paper made using ChatGPT was not plagiarism. To discuss this question, let's look at the presentation that will be delivered by Professor Stefan Koos. Before that, I will read his short CV first. In 1986 to 1991, studies of law and political science in Wurzburg. In 1988 to 1989, study abroad at the Universidad de Salamanca, Spain, for state law examination in Wurzburg. And 1991 to 1994, legal internship. And 1993, legal stage at the German Portuguese Chamber of Industry and Commerce in Lisbon, Portugal. And lecturer at the Academy of Administration and Economics, Munich, and member of the executive board of the Academy. And since 2011, visiting professor at the Faculty of Universitas Islam Riau, Pekanbaru, Indonesia. Since 2016, visiting professor at the Business Law Department of Universitas Bina Nusantara, BINUS. And 2018, visiting professor at the Law Faculty of Universitas Airlangga, Surabaya. You can find many papers from Professor Stefan Koos at ResearchGate, Google Scholars, and on many other platforms. The newest one, Metaverse Beyond the Hype, Multidisciplinary Perspective on Emerging Challenges, Opportunities, and Agenda for Research, Practice, and Policy. Without further ado, Professor Stefan, time is yours.
Maaf ya, saya tidak bisa lihat baik. The Honorable Vice Rector for Partnership, Innovation, Entrepreneurship and Business, Hasanuddin University, the Honorable Dean of Law Faculty, Professor Hamza Halim, the Honorable Vice Dean of Academic and Student Affairs, Professor Dr. Maspun, SHLNM, the Honorable Vice Dean of Planning Resource Alumni, Professor Dr. Idin Katarina Saharina, SHMR, the Honorable Vice Dean of Partnership, Research, Innovation, Dr. Ratnawati, SHMH, Honorable Head of International Law Department, Head of International Cooperation, Dr. Birka Latif, SHMH LLM, and Honorable Secretary of Quality Assurance and Reputation Enhancement, Dr. Marwa, SHMH, and Honorable Heads of Secretaries of the Departments, Heads of Study Programs, and Lecturers within the Faculty of Law, Hasanuddin University, and last but not least, the honorable students and lecturers who attend today. Thank you for coming, even if it's actually a difficult time for today because we had the election and many people are actually at home. So you still come. So I will change my glasses so I can see you again. Yeah. Yeah, today I would like to present you a topic which is not that new because I published that topic already 2 years ago. And this is a basic topic. We talked yesterday much about that. Thank you for picking me up. It's a basic topic for my whole research, which comes after that about the digital law and the cyber law. Because in my opinion, we cannot understand cyber law with all its nuances like metaverse, like artificial intelligence, like blockchain technology, smart contracting, and so on, without understanding the impact of digitalization to the constitutional and also the state law, and especially the international law. So I want to show you in my presentation, first of all, we want to make a trip through the cyber law, and we will see which is the challenge. But more important, and over all this is the question, what stays from sovereignty of states and what stays from the importance of the international law, may it be the conflict of law or may it be the public international law, and with its principles like the courtesy of the people, of the states, the territoriality principle, and so on. So we will see, and I will show you that we have more and more a replacement of legal principles, especially in the international law, by technological instruments, by digitalization, and also we have a disruptive effect to main principles of all the law and principles which are basis of the law, especially of trust in the law. So let's start with some frame conditions. And for me, in this slide, it's important to underline that many aspects of the digitalization of the last decades, let's say 20 years since we start with the internet, are not really disruptive. Anybody talks about disruptions. I hear dozens of presentations about why Uber and GoCar and Grab is disruptive. Disruption is a term which is used in an inflationary way. This comes from the use of this term in the economy. In the economy, many things are disruptive, and they are disruptive already if they change the structure of the economy and to change the structure of the products and the demand of the products. That might be disruptive. But in the law, especially in the civil law, we did not see so far disruptions. We can check that. We can counter check that with the simple fact that we work in 2024 with codifications from the 19th century and the end of the 19th century. So I tell my students in Germany that the best book in the world is maybe for Germany the Bürgerliches Gesetzbuch, or for Netherlands and Indonesia maybe the Bürgerliche Wettbuch. Because we have here codifications which are based on even much older principles like the antique Roman law, and we still use these principles for arranging our societies. How can that be? It can be because there were no really disruptions to the law. But I want to show you that we have now in the digitalization, the first time in the history of the law, we have real disruption, which might bring the general application of our codifications into danger. So you see what I have yellow here. What is not yellow is not so relevant for the aspect of the disruptions. For example, acceleration of the use of new and disruptive organizational digitalization technologies. Disruptive in this sense, technological disruptive and economical disruptive, but not legally disruptive. Internet was not legally disruptive. When I was doing my habilitation and became a professor, the big topic was virtual companies. Virtual companies. Why virtual? Because companies not needing many stuff in the center, and maybe putting the production together with many satellite companies, and then making products after demand with a changing stock of satellites. Yeah, and why is this possible? Because of the internet communication, which was very fast. But actually, this is just the speed of communication, nothing else. It is not the fact that someone communicates, because of course you could do it also with a telephone, but it's not so effective because not fast enough, not real time. Internet gives us real time options, and real time options is the speed, but it is not disruptive because the way how we assess a contract is not different from the way we assess a contract in the traditional way when we speak to each other, or we write a letter and send a pigeon to the other one. So it's not disruptive. So also not disruptive is digital platforms. Platforms are disruptive for the economy. And of course, we have many new challenges with the platform economy in the sense of the antitrust law, because we have a big amount of new methods how we can monopolize something and how we can abuse market power, and how we can gain market power with platforms. Yeah, because especially in the combination with big data. But this is not disruptive because basically the principles of the antitrust law and of the competition law are the same like before. Just we have to think about maybe new case groups of antitrust behavior. But what is really disruptive is the ubiquity of the platforms and of all which is happening in platforms as a counterpoint to the territoriality. Why? Because we are dealing with influences from acts which are not taking place in our territory, but outside our territory. but influence our territory in the same way as if it was in our territory. So if someone writes an information into a platform which is conducted from the United States or from China, it might influence our society in a big way. It doesn't matter whether the information is written in the United States or in China or in European Union. If it infringes a trademark which is in our country registered, the result of the infringement is the same as if someone infringed our trademark in our territory. Now we see the problem, especially if we talk about trademarks. Trademarks is an intellectual property right, and intellectual property rights are territorial limited. This means any country has its own trademark law, and there is a register of the trademark only for that territory. The same happens with the copyright. The same happens with the patents. It's all territorial limited. This means, from the principle of the territoriality and from the principle of the conflict of law principle of the protection country principle, that a national trademark or a national patent cannot be infringed by foreign acts. That is at least the status from the Berne Convention about intellectual property, copyrights, trademark conventions, which all come from the end or middle of the 19th century, and is also the basis of the TRIPS in the WTO, territoriality. But what is left of the territoriality if I say, okay, this is territorial, but we have a result which is big deal, infringe my interest in the local market because someone used the web page, maybe from United States, and write German information into the web page aiming to German consumers. The influence to my trademark, my national trademark, is the same as if someone did it from Germany. It is just casual that someone did it from there. So there is a forum shopping option. Yeah, that means already long, and this is not that new. This is not coming with the digitization like now with the AI or so. This is not new. Already 10 years ago, I wrote in one edition of my book about the conflict of law and competition law and intellectual property that the territoriality principle must be modified, yeah, by a more wider look to the effects. Yeah, so we must combine it with an effects doctrine, which we know from the international antitrust law. Effects doctrine means we assess what effect some act abroad has to the inner state interest of our law. Yeah, in the antitrust law, we would assess whether an antitrust behavior, which is maybe an agreement which is done outside our territory, how it affects the internal market. And if the effect is in a de minimis idea relevant, then we would apply our antitrust law. European Union Commission did that in a case where, for example, computer producers and chip producers made agreement with computer producers in Malaysia, like Compaq and other Hewlett-Packard and so, to not put AMD processors into the new generation of their notebooks instead of Intel. So Intel made this agreement. They are forced to use Intel processors for their new products, and the AMD processor came into the product maybe half year or 1 year later into the new products. Why the European Commission could apply antitrust law from European Union? It is outside the European Union, right? So the territoriality principle should avoid that, because we should not apply our law extraterritorial. But the Commission did that. Why? With what rights? Because the Commission said, yeah, they did that in Malaysia, but the products come to the European market. And in the European market, the consumer can buy this product half year later. So the internal market is affected. That is an effect to our market. And that's why we apply our antitrust law even to an agreement which is done in Malaysia and not in the European Union. And that is reasonable. And I think you already know why I want to come with that, with the digitalization. Because why? Because the European Union said sometimes there is extraterritorial effect necessary to protect our market. And that you can now widen to the data protection. How we protect our citizens if we cannot apply our data protection extraterritorial, we cannot. You can put it to the AI legislation, so the regulation of against for artificial intelligence, how we can protect our market against AI models if we cannot do it if the model is done from United States. So we protect our markets, and this effect is typical for the digitalization and for the platforms, because due to the platforms, we cannot anymore separate territorial effects and extraterritorial effects. Whatever happens in the platforms influences more or less internal markets. And depending on the amount of influencing, it can be necessary from a pragmatical view that the law of a national market must be applied. So we will have a tendency to extraterritorial application of law. And that is what I call really disruptive. Why? Because the decision whether we apply our law extraterritorially depends on the political and economical power of this country. Why? Because of course Brunei could say we apply all our law extraterritorial, but how many companies abroad will respect that? They don't care. They say, okay, then they don't care. Then Brunei will say, we fine you. Then they would say, then fine us. Then we go away from Brunei market. We don't need Brunei market. But will they stay away from the European Union market? Most likely not, because they need these 300 million consumers for their market. I cannot say that the European Union has a big political power, at least not that big like other blocs like United States or China, but it has a big economical demand power, and this demand power makes them respect our law. So at the moment, they respect our data protection law, even if we apply it extraterritorial. And also the new regulation on artificial intelligence sees an application externally. Yeah. So this is disruptive, because I call this a crisis of the international law, because normally the problem of extraterritoriality lies in the conflict with the international public law, the courtesy of the states, to take care that we not mix into inner affairs of other states. We should not do that. This is a rule of the international public law. But this rule is not anymore very valid, because when there is a pragmatical reason for applying our law extraterritorial, we will do it. So it is not counting on the law. This is the first replacement of law by a political principle, by the political principle of the power of the stronger. The stronger bloc has more option to apply its law extraterritorial to other territories in all over the world. So we see one of the main points of my presentation today is displacement of the law. We displace a legal principle from international public law with a political, economical principle, the principle of power. But we will see there are more aspects where we replace. You see here, this picture is done by DALL-E, by artificial intelligence. I know in 2 years, nobody will be interested in these illustrations, because any idiot can make these pictures. But in a moment, people always say, wow, what an illustration. I did that in less than 1 minute. This shows a courtroom and with people here, and the judges are robots. Yeah. So I have a doctorand who's working about replacement of the courts and legal court decisions by technology, especially by smart contracts. We will see a shift indeed. We will talk about that later. So let's start. What issues we have here, what phenomena we have here to talk about. So it's first of all, the artificial intelligence. Artificial intelligence can be a weapon, but it can also be a defense. So if I am, as an individual living in a society, if I'm threatened by the use of artificial intelligence, for example, in the advertising, then I need equality of weapon. So of course, I also can use artificial intelligence as a defense to identify dangers. Yeah, we will see already the war of algorithms which are used for hacking. You can use AI for hacking, yeah, to find out weak points where you can interact or intrude in systems. And it is already like this, that not humans can just analyze that all the time and then defend against this, because it's very fast and very effective. So there will be algorithms which check these attacks and will counterattack. So we will have a substitute war, not between human IT guys which check around and try how to hack, but we will have algorithms with hack and algorithms which defend from hacking. This is already a replacement of the humanity with the machine. The machines are used, and of course we can defend ourselves with hacking is forbidden, but it will not work anymore. So better we use technological instruments to protect us and not trust the law. This is one of the first issues where trust is replaced, because there is a systemic trust in the law which is going away, because we think, well, the law cannot really protect us effectively. So this is one of the effects. One other aspect is the smart contracting, and combined with that, with the smart contract, is the blockchain technology. Smart contract is Takite, is combined with the blockchain technology. What does it mean? It means we deploy a smart contract algorithms in a platform like in the Ethereum platform, and this smart contract is executing something automatically. Many people think that is automatically AI, but it has nothing to do immediately with the AI. Smart contract is nothing else than a digital vending machine. You put a coin into the chewing gum machine, and that chewing gum comes out. You put a coin into the cigarette machine, the cigarette comes out. That's all. The machine is programmed. If there's the right coin, the right product will come out. Nothing else does the smart contract. The difference is that the smart contract is not changeable, absolutely controllable and transparent, because the smart contract is deployed in a, from our knowledge, mostly not manipulatable blockchain. Blockchain means we have it in a row of data which cannot be taken out in the middle without changing the whole sum which comes out in the end. Just simple expressed. This is actually the topic for a full presentation to explain how blockchain really works in a detail. But this is more or less the thing. So why is this a problem for the function or for the role of the law? Because I told you that smart contracts can replace courts. Why? Because, for example, if I make a contract with you that you have to pay me a certain amount of money if I deliver you a certain product, I can do that from Germany with Indonesian, but if you not pay, then I must sue you. And where I sue you, or I do it in Germany, then it's not sure that you come to Germany and you respect the German court decision, or I must do that in Indonesia, then it's not clear that Indonesian court will help me here, or how fast it will be. Yeah. Of course, I can make arbitration, or I can also, maybe we can decide about a neutral court, but this is all very complicated. So if I don't have much money and it's not a big amount of money, yeah, then, okay, he doesn't pay, what can I do? But if I deploy a smart contract, which is exactly doing something in a certain condition, so if I say I delivered and I can give a proof, then automatically the Bitcoin will be given to my wallet without that you can anything do against that. Then I don't need a court anymore. Yeah. But that does not mean we replace the law totally. It means only we shift the legal conflict from the enforcement of the contract to the product responsibility, because now the problem lies in the programming of the smart contract. If the smart contract is not correctly programmed, then this is a problem for the parties. So we would sue the IT guy or the lawyer who makes the contract. But the court decision we don't need. So this solves certain problems we have typically in the ubiquity of platforms, because in the platforms we interact internationally. So for example, if I have a copyrighted work and that copyrighted work is copied by someone illegally in China, it is possible maybe that I put some water sign in my copyrighted work, and when this water sign is found in a page which is not legally using it, it can be that automatically royalties will be sent to my wallet from this Chinese guy, Without that, this Chinese guy can do something against them. So I don't have to claim for the copyright infringement anymore. Yeah, this is replacing of law. This is very important. And now even better is if we combine it with the AI. The AI is monitoring situation, and if the AI independently finds a certain situation, it triggers the smart contract. No human involving necessary anymore. And then finally, the tokenization, which is also combined with the virtualization. In the metaverse, for example, we will talk about virtual property, which is not yet totally developed. And this can be very disruptive because our system of property is based on tangible goods. But the virtual goods are not, as also not like intellectual property. It's something which is not tangible, but is persistent. For example, if I have an augmented reality glasses, yeah, I can have a persistent item which anybody sees who is in this platform as if it's real. And in a metaverse, I can have a house, I can have furniture there, I can have an artwork there, and that artwork is, or my avatar is saved with a token. Yeah, and we control the token with technology. How we in the future will define someone who is, which identity has with tokens in the blockchain. Yeah. So this leads to something which is old. This book here is already from the 80s. This is from the German sociologist Niklas Luhmann, Das Recht der Gesellschaft. For those who know a little bit about the Dutch language, the Dutch legal language, Recht is Recht is in Netherlands, and in Germany we say Recht. We don't make the we make the yeah. So das Recht der Gesellschaft means the law of the society. And in Das Recht der Gesellschaft, Niklas Luhmann wrote that in situations where the citizens don't trust that the national law will protect them, can protect them, or want to protect them, citizens or societies have the tendency to seek for alternative instruments to protection. Yeah. So, for example, in societies where the people don't feel represented by the state law, they might maybe find an alternative law in alternative, maybe particular societies. Maybe in the with the priest decide about conflicts when they not trust the state courts or something like this. And Niklas Luhmann did not think about the digitalization like this in the 80s, but it is applicable to the situation nowadays, because we feel more and more that we are subject to digital infringements, which cannot anymore be protected against by state law, because state law typically is territorial, and the infringements are ubiquitary, not territorial. So how we protect ourselves from damages which come from outside our territory? As a citizen, we might give up, or we might be believing that the state will do something, then we will find out that we cannot be protected because the state power ends in the border, or the political power is so strong that it is extraterritorial, or we find alternative instrument in the technology. So if I want to protect me against infringement of my copyright by Chinese or by someone far away, then I make a water sign and put it to the blockchain and add it with a smart contract technology, and then I can trust my money will come automatically without needing any law. So this is an alternative instrument for protection. Tokenization can be used as an alternative instrument for protection. AI analyze my interest and defends me automatically with counter defense in the IT. It's an alternative instrument for protection. We see that very clear in the data protection law. In the data protection law, imagine you have an augmented reality glasses from a company in China or in Vietnam or wherever. I don't want to all the time bully here China, because China is not worse than maybe United States companies who collect our data. Anyone collects our data. So imagine, let's say China. Imagine you have a Chinese product, because typically they come from China, augmented reality glasses from a Chinese company, and these augmented reality glasses you can wear, and then you make like this, and then it is on and online, and wherever I look to the person is analyzed. There's a face detection, whether that will be allowed in the future with the AI regulation we let open, but it gives me automatically information about you. And also the glasses know what I do. If I look at you and look at you, whether I'm tired, whether I'm attentive when I'm tired, when I'm excited, when I see a product, this is all information, and this information is going to someone. And maybe it goes to China. And that is a data protection law, of course, highly problematic, because data protection law in Indonesia and also in Germany does not allow us, by the way, also in China, does not allow to send private data to a country abroad. It must be a safe harbor country. And for European Union, of course, China is not a safe harbor country. So what is the alternative? The Chinese company could assure us, we will not do that. We will respect the data protection law. We will not send data, but how to control it? Yeah. How we control that there is not a backdoor. You know the Huawei cases and the reservation of the United States about Huawei technology in the data communication and telecommunication. Nobody can know what backdoors there are to send data. And typically in certain countries, data are used from the state for maybe not the reason just for marketing, but also for political reasons. So how we protect ourselves? We have the data protection law that will protect us. So I ask you, who of you feels really safe because you have data protection regulation? Isn't it rather like this, that we are knowing very clear that whatever we do in the internet is observed, and then whenever we want to see a web page, we must click Setuju with the cookie and whatever. Yeah, they inform us about the cookies. We can read that. Who reads that? Before I can see the web page, I must read a long list of what they do with the cookie, but I have no idea what it is that we call information overflow. This is also a sort of a dark pattern, because they know exactly nobody reads that. So they can write whatever they want into that cookie declaration. Yeah. So that means we know. So there is now the difference between certain societies. Indonesian society is very open-hearted. Yeah. So you open everything to the internet. So if you go to the Meta or the Instagram, you see dead grandmas in coffins. You see your children bathing, and I don't know what else. Yeah. Don't do it. Yeah, because you don't know who used the photos, and don't forget there is deep fakes. Someone could use the picture of the face of your child and mount it into some naked pictures and then sell it as children pornography. So don't show your children. Don't trust. Nobody protects you, actually, because who can protect you? Why? How can Indonesia protect you with the data protection law? It's not the fault of the Indonesian legislator or the Indonesian government. It's because we have ubiquity instead of territoriality, and what counts is what comes from outside, and that cannot be controlled. So whatever they do, they can do it, and we can never find the one who mounts the picture of your child into that dirt. So we are not protected. So what we should do, we should be self-responsible. If we're not self-responsible, we cannot protect. So we must be clear that data protection law collides with the reality. And that's what I mean, clash between legislative claim and of control and reality of the ubiquitarian society. The infringements are typically ubiquitary, and the claim of the law is we protect our citizens by making a law. But this law cannot be enforced properly. As we saw in the pandemic, I had to teach with Zoom, but Zoom was forbidden to me, because in my university, we don't allow Zoom, because Zoom has servers in the United States, and the IP data of my students go to servers in the United States. So I was forced to infringe the law permanently, because otherwise I could not do my work. I didn't have an alternative product. And do you have alternative product in Indonesia? No, you use Zoom and the Teams and whatever. Yeah. So we are forced to infringe our law because we know we cannot do something else, and we know we infringe the law, yeah, and anybody knows we infringe the law. So there is a clash between the reality of the use of the data protection law and the claim to protection, because there is no protection possible. So isn't it better to make a pragmatization of the data protection law, to accept that we cannot do that, and then rather claim the self-responsibility, instead of having rules which are anyway not enforceable and make erosion of the trust in the law, because anybody knows we cannot be protected, but anybody knows it's written in the law. What does it mean? Yeah, they write something, but this is erosion in the trust, in the systemic trust of law. This is a real problem. The second aspect I want to make very short is the question of data ownership, which is a little bit, maybe partly disruptive, because that is a little bit difficult to understand because the data play a big role for companies nowadays because data means power and data are property. And also for the private person is data possibly necessary because the data protecting us, if we give them data away, it's a value for the company. But for us, it is a question of protection, how we license the use of our data. And data protection, personality protection might be necessary in the future by combining it with property aspects. What I want to say is, as the data protection law in the reality cannot be properly enforced, maybe, we might have a shift from the prohibitive protection by data protection law to a property law aspect by giving every citizen property of its data and as seeing the giving the data to some platform as a sort of a license, which should be reimbursed in a certain way, but at least give the individual the power to take it back. However, very short, the idea of data are the oil of the 21st century is not correct because oil is limited and data is unlimited. You see already it's not so easy to assess that, but this will be one of the questions in the future. A shift from protective aspect in the way of prohibitions to a more property related aspect of data protection. Another challenge will be the neuroprivacy and the dark pattern. Neuroprivacy will be the next step of dark pattern. First of all, what is dark pattern? Dark patterns are instruments of relation between advertising and consumer, where consumers are deceived by several methods to do something they otherwise would not do. Psychological tricks, but also checking out emotions and then react to emotions. For example, if I'm going to Amazon as a platform and I'm interested in an item, but it's expensive, then I looked at item and I remember I wanted an item, but my wife said, it's expensive, don't buy it. And I owed some grand and should I buy? And then she said, no, for what? And then back, and then again, go back to the platform. And I did that over 1 week. All the time clicking that, oh, I want it, and then really wanting it, yeah? And then what Amazon did, always make it a little bit cheaper. Baiting me. So in the end, I ended up with buying that because suddenly they make me special price, yeah? Suddenly I got it instead of 49 euro for, I don't know, 45.99, which is not really relevant, but psychologically, yeah, this is now occasion. Now I buy. They check out how is the price elasticity of someone. But more important is that Amazon knows for the future how I react, that I'm not buying at once, that I always check, and they know how far they have to go back, how many percent they must go down. If I did not buy it with a 45, maybe they tried with 39. And then they know this guy is a tough guy. But with me, in my case, they know I'm not a tough guy. So they don't have to go so deep down. This is also manipulating. Or they make us tired with information. And then in the end, when we read that all, they give us a click. And this is so easy. Click. Actually, I didn't want it. Yeah, this is dark pattern. And dark pattern can be combined in the future with artificial intelligence because artificial intelligence can assess how strongly we want something. Yeah, because the artificial intelligence can, for example, check our emotions and can I read, for example, that AI systems can know whether we are tired or whether we are sad from our reaction or from our eye moving. Also, that is an issue of the data protection of the AI regulation. We are not sure how far that will be forbidden, but this is possible. And the next step will be the neuroprivacy. You know, this guy from Tesla is experimenting with neuro modules, putting into the brain, and then we are in the metaverse moving around, and then they know whatever we do, and they can then the avatars interact with us in a certain way, and they know our emotions. If they know our emotions, we are controllable, absolutely controllable. And this is dangerous, and that's why we must think for the future about data privacy and neuroprivacy. Yeah, neuroprivacy means, and we are not prepared for that, but some states already have that, means that we need legislation maybe in the future which forbid this reading of emotions a direct reading of emotions by the combination between the organ and or the human body and the assessment by AI. Neuroprivacy. We have already in the GDPR something, in the General Data Protection Regulation, something which could be applied for that. The safety by design and default. It means a system should be safe from beginning. It should not involve that, integrated. Unfortunately, data protection law in Indonesia forgot to implement that safety by design and default. So that might be a problem. Chile has already a neurodata carta. So Chile is already integrating a fundamental right of the individual to not be influenced by neuroscience. Smart contracts and trust. This is really disruptive. Because if a smart contract makes contracting, is this a contract in the sense of the civil law or is it not? The smart contract contracts with us, or the AI, better said, the AI contracts with us, or we contract, we have a contract between two AIs, not necessarily as a smart contract. AIs interact contractual. The question is here, who can make contracts? For contracting, we need legal capacity. And legal capacity is given to human beings and to associations and juridical person. And why it is that is because, or we follow the fiction theory of Savigny, or we follow the reality theory or the group theory of Otto von Gierke or whatever. But one thing is clear, it is not yet decided that AI can be a legal capacity, even if there is suggestions to do this. And why is this? We must see the basis of the contractual and of the declaration of intent in contracts. Why we have declaration of intent and why we have legal privacy and why we have the freedom of contract, the private autonomy. Because the human being is free. Private autonomy is an instrument of the civil law which is directly combined and connected with the human dignity and the freedom concept of the human. Even in a group or in a foundation, we have a human will. The foundation has the human will of the founder, and the association has a combined human will of the association members. So the human freedom is the basis of the private autonomy, and the private autonomy is the basis of the civil law and the contract law, right? And why the human is free, I show you here Jean-Paul Sartre, the big existentialist philosopher in France. And he said, human being is sentenced to freedom. Sentenced to freedom, what does it mean? Sometimes humans say, I didn't have the choice. Yeah, I had to do that. I was forced to. I was forced to kill someone. I was forced to not kill someone. I was forced to comply with the law. I was forced to make suicide. I was forced to not make suicide. Yeah, human being is sentenced to freedom. There is no nature of the human being that fixes the human being, but the human being is what it makes himself to be. Absolute freedom of the human being to choose. And this is, first of all, you can do whatever you want. Whether you want to make amok and kill a lot of people is your freedom. I don't say it's legitimate, yeah? But it is your freedom. It's the free decision. The human being is free. And I decide to not be a killer. This is because of myself, not because society makes me not to be a killer. Of course, if I be a killer, maybe there's death penalty or go my life to jail. But this is my choice to go to jail then. If I don't want to go to jail, I don't do it. But I have still the choice. Even if I'm 1 second before dying, I have still choices. Yeah? But how is it with the computer or the AI? The AI has no freedom to choose. The AI is maybe determined in a way, but it is surely fixed and determined by the programming. Even if the AI can be autonomous deciding something, it is not because it's based on the free will to be something. There is no existence and no individuality of the AI. Even if AI has a lot of options free because the programmers make a lot of deciding options and they are maybe flexible, the AI has no wish. And if AI cannot have wish or intent or desires, and the desire is the basis of the contract because I want something, or I need money, I want money, or I want to serve, or I want to work, as AI cannot have desires, AI cannot have freedom, and AI cannot have intent in the civil law. This means if we want to make contracts done by AI something legitimate in the law, we must accept that that would be a clearly disruption of the principle of the private autonomy and therefore of the basis of the contract law. We cannot just integrate AI contracts into the law without or making a very strong analogy which sets the basis, the philosophical basis of the law in danger, or we decide to develop a sui generis way of making contracts and separate it from the private autonomy. But then we must argue why that should be and where is the legitimate point for that, maybe from pragmatical reason. But we cannot just say, okay, we have a contract law, and whether that is a human being making the contract or the AI is a contract doesn't matter. We have a contract here. This is not possible because the philosophical basis of the law is gone. And this is the first real disruption in the civil law we see so far since the end of the 19th century. So I want to go fast through this possible role of AI in mitigating risk of dark patterns. Of course, AI can be used for a good, okay, also, yeah, I already mentioned that in the beginning, but more important is the AI as a replacement of the human factor in other ways. For example, in the antitrust law. Some years ago, there was an issue that German airline Air Berlin was going bankrupt. Suddenly, within seconds, the airline Lufthansa raised the price for the domestic tickets 30%. Suddenly. So the German Bundeskartellamt, which is the compatible body of like the KPPU, they were investigating the case, and Lufthansa said to them, we did not do anything wrong. There's no infringement of antitrust law here because we didn't do anything. It was our algorithm. Our AI controls the market, checks the market, and reacts to market movements. So the AI decided to make the price higher. This is also disruptive. Why? Because antitrust law is based on behavior, antitrust behavior. And AI doesn't behave. The AI is not a human. Behaving means I want to behave. Then think of Jean-Paul Sartre. I want to be something, so I behave in that way. The AI is not wanting to something. The AI does what it is programmed to. So the AI did not behave. The AI can therefore not infringe in antitrust law. It can be only infringed by humans or by organizations of humans. So how we deal with that? So one aspect is to give the AI legal capacity. Then the AI is the responsible one. But then we have to change the basis of the antitrust law. Or AI is dealt like with as an employee. So the employee of Lufthansa is the AI, and we assign the responsibility for the employee to the company. So we assign the responsibility for the algorithm to the company. So this is more or less the approach of the legislation of AI. So we make high risk, middle risk, low risk, and we assess risks to someone, to the deployer, to the programmers, to the one who used it. Same as we assign the risk of companies of using a car to the car owner. And the same happens, of course, to the self-driving car, which damaged something. Yeah, it's not the AI responsible; it's the owner who has the profit from using the car. This is disruptive. You see, behavior in the whole law is the behavior relevant, and behavior is not so relevant anymore if we use AI and replace human behavior by AI. And then we need to change of the basis of the law because behavior cannot be the only point for connecting it with some conducting instruments. Yeah, behavior is done. So we can say if we use AI, and the generative AI is another good example for that, behavior lose its importance, and behavior is the basis for the law because law is because of conducting and influencing behavior of the citizen. So we have law because of prevention, general prevention, specific prevention, but also to conduct behavior or to give incentive. Incentives are not working with AI. AI has no intent, no wish. So there cannot be incentives and there cannot be fear. AI cannot be punished because AI is not respecting the law because it's afraid to go to jail or be switched off. The law will not function then anymore. And another aspect is the trust. Law based on trust. Why I make a contract with you? Because I make a contract with you because I trust you that you pay the money. Yeah. If I'm in the metaverse interacting with avatars, and I don't know, first of all, who is the other avatar, and second, is the avatar maybe an AI? How I can trust here? So in the metaverse, we need to solve the problem of the trust. Otherwise, it will not work, because without trust, trust is the basis term for the law. Trust in the legal system, which is diminished. Trust in the individual, which is diminished. Yeah. And also we saw that trust in that someone can be influenced, which is diminished. And trust also that what we see is really what we get. Generative AI produce pictures, produce text, and we don't know, is it real or not? Is it fake? Is it biased? This is all very dangerous. And I show you this picture here. I made it yesterday in my workshop. And I want to show you how the AI will change our idea about what is reality or what is art. Yeah. What is your impression with this picture? What you feel when you see this picture? Is there any? Can someone of you say, what do you feel when you see this picture here? What is your? Give me just your spontaneous feeling. It makes you good, makes you feel good. Makes you feel good. Really? My idea when I see these pictures is I feel not very comfortable. I feel somehow afraid. Why? Because this is like a nightmare. On the first side, it looks normal. There is this Chinese philosopher, and there is this nice landscape. But look, this strange angel there. Yeah, this is somehow nightmare. And the AI seems to materialize human nightmare and make it seem normal. So this is already influencing a lot, yeah? So this is one of the challenges, how we protect our societies from influence our art, our perception of art, our perception of the reality against this influencing that these AI products might seem that is normal for us, yeah? And another question is how we handle exploitation, for example, of copyright, for example, by AI. Yeah, the exploitation of AI, for example, they train their systems with a lot of data. Why I should in the future write a book or a poem if some idiot can do that in 1 second? Why? This is one side is good. I could talk with you yesterday about that. Plagiarism is from yesterday. We don't have to care for plagiat because only idiots do plagiat. If I want to write an article about copyright and AI, then I feed my GPT with 5 PDFs about that topic, which are already written in Indonesia, and tell the AI to make a new article out of that, but don't use the same wording, make an absolutely new wording, write in the style of a German writing English, and don't use seldom words, and so on and so on. And then you add a little bit of yourself, and then you have a new article. It seems bad, right? It seems bad. It's not that bad as it seems on the first sight, because how many people write articles just reading articles and then write the same just in other words? Yeah, also we find 10,000 articles which are not really making the science totally new, right? Because it's all the same. There are 20 articles about cyber notaries, all the same. Nothing new, no novelty. Yeah, but this is not the problem. The problem is why I should have incentive in the future to write my own article if anybody can take my articles and make something in seconds. Why I should make this effort? Why I should write a book about growing roses if any idiot can buy a book growing roses just paraphrasing my own text with AI? So what will it do with our culture? Not only how we protect our intellectual property, also what will it do with our culture? Will someone buy in the future books? So there is several options. What will be the future? I cannot see into the future, but I can say I think there will be the renaissance of classic, so that people will read old books again. When we can be sure these are classic authors, they wrote with their own brains, because the people will be bored in the future seeing all this art. We have already inflation of texts which are written by AI, poems which are written by AI, pictures which are done by AI. People will not be impressed anymore, and then they will be bored, because you cannot trust that it's really written by people. And then they will pay maybe more for a real book written provable by a real author than for all these masses of books which are written by AI. Like people pay maybe $50,000 for a mechanical watch, even if the Apple Watch is much more accurate. For what I should buy a mechanical watch though, yeah? So because people like the nostalgia. I hope it come like this and not the other way around. So we can conclude with all these examples that we have a loss of importance of the law in the digitalization. I call it 5-0. This is also very much in fashion. It's 2-0 and 3-0, 4-0. Let's say 5-0, doesn't matter, but a loss of importance. First is the interpersonal trust will lose relevance. If I don't trust you anymore, I make a smart contract because the smart contract automatizes it. I don't need a court. This is a loss in the systemic trust in the law, and I don't need to trust you because I know it will be automatically happen if a condition is gone. For what I should trust you? This is a typical instrument that we can use when we have metaverses and we don't know who is our counterpart, for example. Yeah, even if there is, of course, instrument for integrating trust by making individualism. For example, we can use notaries. Notary make a deployment of an identification token in the blockchain, and this identification token can be anonymous and can be done for a certain time, only for a certain purpose. And then it is clear this is one certain person because it can be proven in the blockchain. Afterwards, you are anonymous again. Second, trust in security and in control by technology, for example, blockchain technology, smart contracts, as a consequence of the loss of trust in state protection by regulation due to the ubiquity. Yeah? So we replace the trust in the law by the trust in the technology. We use technological instruments to protect ourselves more and more because we cannot trust that the law protects us properly. This is also a little bit like this idea of the West Coast Code and the East Coast Code, yeah, of Lessig, Lawrence Lessig. Lawrence Lessig talk about East Coast Code and West Coast Code. What does it mean? There's the code in the East Coast from Washington, from the legislator, and there's the code from the platforms in the West Coast in the Silicon Valley. The Silicon Valley takes over more and more power, which replaces the legislation power because it's a factual power which conducts the society and not anymore the legislator. The legislator comes in conflict with the technological codes. All is code, legislation code or technological code, but the technological code takes over more and more. Then automatization and determinism, like AI, smart contracts, will be instead of incentives for compliance and of law enforcement. Incentive for compliance is yesterday. Yeah, in the future, we will not trust on incentive because AI algorithms will act, will influence markets, will make maybe contracts, will behave in the determined way. And this means we cannot conduct what happens in our society if we work with incentive because the AI is not open for incentives or for fear. This means we need automatization instead of incentive. And finally, we have a certain loss of the constitutional basis of the private law if we abandon the freedom concept of private autonomy. And the more we have AI interacting in the civil law, the more we will abandon this freedom concept. So altogether, we see as a consequence several not so good aspects. We have maybe a shift more to utilitarianism. So it is something is very useful. I all the time talk about pragmatic here. It's useful. It does not mean that it is automatically also ethic. Yeah. If something is useful and effective, it's not automatically ethic. So the question of the future will be how we integrate the justice and the ethic into the conduct of societies. If everything is determined or done by AI or technology, because the technology, first of all, has no ethic. We see it already in the generative AI. We asked the generative AI something about should women work after they study and if they have a family, or should women still stay at home and just raise the children? Do women have more rights, same right like to work like men and same right to salary like men or not? I don't know what the AI answers, but some AI might answer, there is a good reason that women should earn less or women should stay at home because children need the mother or something like this, yeah? Why the AI could answer that? Because AI could be biased. If 2/3 of the people in the world think that women should be at home and women have less rights, then who is writing in the Google? These 2/3 of the people writing in the Google and writing texts about that, and the AI is trained by a lot of text. So if the AI is not educated, then the AI will reflect the main opinion of the world population and not the opinion maybe of our country. So maybe we have a peculiar idea about that. We saw that in Qatar, yeah, that Germany has a very liberal idea about LGBTQ, but the Qatari did not agree with us. So we were very special, yeah. So do we want in our country be influenced against LGBTQ? Not. We will not. But Qatar will say we don't want to be influenced by the Germans, yeah. So what is global idea? Global idea is not existing. So how we protect our society idea and about the decision of how we want to have our society and how not in the future against this bias. And the AI in the beginning is just like my 5-year-old daughter. My 5-year-old daughter now behaves a little bit, but when she was 3, and we go to the supermarket and she sees a papa with one leg. Good puppy, he's one leg. Should we do that? Would you do that? I would not look at the papa. Oh, you one leg. Looks funny. We would not do that, right? Because this is really bad behavior. But how can my 3-year-old daughter know? And how can the AI know? The AI is not intelligent. The AI is trained by a masses of data. And which data this is, depending on who trains them. There are in Africa hundreds of people just checking out photos of pornography, whether it's children pornography or not, because the model makers, they are afraid that the picture models, this DALL-E and these other models, maybe produce children pornography and think this is normal. Yeah, but it should be excluded from this. So people say, make me a picture of someone doing this, and there comes child. It cannot be, yeah? But the AI doesn't know that children pornography is absolutely immoral and also forbidden. So if the AI is not trained, it's like a baby knowing nothing. And this is a very dangerous aspect, and this is the question of the future. How we integrate this justice and ethic, and not only ethic as a pluralistic concept, but maybe even in certain countries, the moral. For example, China says AI should not infringe the interest of the political system of China. Yeah, China doesn't want to have political influence which coming from more liberal countries. Yeah, so this is moral. This is not maybe not ethic because it's not pluralistic, but this is also moral. And China actually has the right to do in their territory what they want, how they protect each other. China is in a very ambivalent situation because on one side they need this technology because they want to be top of the technology. Second, they need the technology because it can also be used maybe for controlling the society in a certain way. But of course, the AI can also be used to attack the political system. Yeah. So this is a very ambivalent technology, and we don't know yet how to control it. So in the end, what is the role of ethic and justice in the future, and how we have the influence in the future? And I predict that Indonesia, when Indonesia will make the AI regulation, we have now the last draft of the AI regulation, which is approved by the ministers of the European Union member states on 2nd of February. So in April, it will go to the European Parliament, and then will be in power maybe in July, August. We will have an AI regulation, which is more pluralistic, not talking about the political system. But Indonesia is also planning that still in the recent legislative period. I think they will not maybe make it so fast, but in the next period it will come surely. And as the GDPR was the model for Indonesia in the data protection, Undang-Undang Data Pribadi, I think Indonesia will also take the AI regulation of European Union as a model. By the way, why they copied the model of the European Union? My theory is that Indonesian legislator, they are very clever. They know it is very difficult to enforce the law internationally, and there will be maybe not respect to the Indonesian legislation. But if they make the same principles like the European Union, and we have global principles, and the chance to enforce that globally is much higher. So let's see, maybe the regulation of the AI will be very similar to the European Union regulation, because we are maybe closer in our ideas than maybe China and Indonesia from the approach of the legislation. So is the AI really controllable? Mrs. Verstegen, for the first draft of the AI regulation, said this is a landmark for trustable and human-centric AI. I'm a little bit more pessimistic, yeah. It depending on how we can really enforce our regulation extraterritorial. For the beginning, it will work, but on the long term, I'm sure maybe not so workable. And the question is, should we forbid it? Of course, there is no realistic way to forbid it, because we cannot just exclude ourselves from the technological development. We must face it. And that's why I say to young students, to you all, you will be maybe later work in law professions, Please don't ignore the technology. Don't be lazy. Make today, tonight, make an account and experiment with that and learn about that, because the future will be disrupted. You will be notaries, you will be lawyers, you will be public servants, you will go to law firms, you will go to companies, and the way of working will be absolutely different than the way of working when I became a judge. Yeah, because your task will not be making texts anymore or making drafts anymore. Your task will be controlling and prompting, and the AI will replace a lot of jobs also in our profession as lawyers. And if I want a future, if I was you, then I would be prepared for the enemy coming here. Because I'll be honest, I would like to live in the 80s again, because in the 80s we had different problems, but not these problems, yeah, which is really bringing our society into a certain danger if it's applied in a wrong way. So it's always better if you know the wolf will never go away anymore. I will have to face the wolf, then better know the wolf and know the weaknesses of the wolf and the strength of dealing with the wolf. Better use the wolf for yourself than be surprised by the wolf. So this is my advice to you all. And with that, I am ready. Mr. What is the name? Or Mr. Weizenbaum already in the 80s said that we cannot say, okay, technology is something bad, but we also should not allow technology-centric societies. We should not give the technology too much power over society. How effective we can protect ourselves, this will the future show. Thank you very much.
Thank you, Professor Stefan. A very nice presentation and provide knowledge for all of us about digital globalization, ubiquity instead of territoriality, acceleration of the use of new and disruptive digitalization technologies, the rise of digital platform and big data monopolies, how difficult it is to implement data protection rules, neuroprivacy and dark pattern, disruptive impact of artificial intelligence, and many more. I have one question related to technologies. I want to ensure that technological developments are not the replace human in their work, but to help human in their work, right?
Yeah, theoretically it should be like this, yeah. When we will hopefully soon have a workshop on using AI for writing articles here in Hasanuddin University. And what I tell the students always is, don't use the ChatGPT for replacing your creativity or replacing your text writing. Yeah, use it as a buddy, as a research buddy. Use it as someone who helps you to find your ideas or helps you to structure your ideas, and then and use it for the boring parts like methods or something, which is always very boring, right? This is not really novelty and creative to write an article and write the method part, for example, or make the abstracts. For that you can use it. This is really not replacing the human. Sometimes people ask me, the ChatGPT, nobody will be creative anymore, and then we make bachelor thesis and just click. Yeah, the bad students will make bachelor thesis and just click, but then they will produce a lot of unimportant blah 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 texts, which are not. But however, anyway, yeah, because there are so many articles in all over the world in the research grid which are blah 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 text, because just someone produced text, right? And if you are forced to produce per year 10 articles and we don't have anything to say, it's also blah blah blah. But at least it's our blah blah blah, yeah. But the right way to use technology is to help us. Of course, we can use AI for maybe to find new medicaments or to find ways how to protect Jakarta from going down or whatever. But of course, also we can use AI to find new viruses, which make the new global pandemic in the interest of some countries, so biological wars or new biological weapons or whatever. AI can be used for everything. And I ask you, is it really realistic that we only use the technology for the good or not? This is not realistic, yeah? What can be done will be done by someone. Of course, atomic nuclear energy could be used for a good purpose, but the first they did was buying atom bomb. Yeah, so or genetic influencing, so changing the genetic of an animal or of a human. It can be used for finding new medicaments or helping people with genetic diseases. But the first they did is in China was making trying whether someone can have the genes of a pavian in a human genome, yeah, or making clones of someone or something. Is cloning of sheep really necessary? It's not a good purpose. So no, yeah, it should be like this. But if it's not used in an ethic way, it will replace at least part of humanism.
Thank you, Prof. Stefan. Once again, please give applause to Professor Stefan. Yes. We are entering a question and answer session. For participants who want to ask question, please raise your hand on Zoom or write question in the chat column in Zoom. And audience in here, please raise your hand. If you have a problem with English, please ask in Bahasa because Professor Koos can, yeah, okay. Can also
with understanding Bahasa when micro or too far, and then I don't understand well.
okay. Because Prof Koos can also speak Bahasa very well. Yeah. One. Yeah. Mike, please.
Thank you so much, Sir Kadar, for the change. Good morning, Prof. My name is Farah, and I'm from International Law Department. And thank you so much for your amazing explanation. And I think this topic is so interesting, especially for us as an international law researcher. And I found your research paper here, Prof, in Scientia that published on 20 and 22 under the title Digital Globalization and Law, and it is related to your presentation today. And there's one point that I would like to know more and get more detailed information from you, Prof. On your third point discussed that mention about the replacement of trust by the technology, which is as the central aspect in this context is the replacement of emotionally by determined rationally. Law is a mechanism that reduces the complexity of social interactions by providing the basis for trust and in regulated social processes. So I can conclude that, correct me if I'm wrong, Prof, the trust replaces the law. From that point, I would like to ask two questions, Prof. The first one is, according to you, is there no unbalancing between law and digital globalization? As you mentioned before, the regulation cannot be enough protect our data protections. And the second point is, what is your solutions or maybe your personal insight for nowadays digital globalization problems, especially to minimizing the conflict between the law and the data digital globalization? Thank you so much.
Not totally correct. I said that basically without the law, what happened? If I want to make I want to interact with you, I must trust that you will not harm my interest. Yeah. So this is when if we have no law, then we must maybe trust on social customs or friendship or the friendshipness in a clan or whatever. Yeah. So this is also trust instrument, but without any of these instruments, we cannot trust. Yeah. So we must trust a lot. So we must trust a lot, but we have no. But it's very difficult to trust someone who is a stranger. So if I don't know you, I cannot just give you borrow you 10,000 euro if we don't have a contract. Yeah. Unless I trust that you will be honest. Yeah, it happens to me, for example, that I made something here in Indonesia. My wife, by the way, made it, and then I said to my wife, "We have no chance to sue him here. Yeah, so this takes a long time. I have no idea about the Indonesian justice system. If he wants, he doesn't have to give it back." And she said, don't worry, nothing happens." And Indonesia is obviously like this, that sometimes even if you don't have a hard contract, people can be very honest, and we got the money back. So this was no problem. Yeah. What I mean with that is that the law makes it more easy to interact because we don't need this personal trust, because we have a systemic trust into the functioning of the law. If you're not giving me the money back, I go to the court, and the court will force you. So I trust that the law helps me to enforce my interest. This is replacement of trust, but in the sense that we replace personal trust. We don't need that much personal trust anymore, and we replace it with the instrument of the law and of the justice. Yeah. But still, I need personal trust because I don't want to go to the court. Depending on how effective the legal system is, it depends on how much I can trust here or how much personal trust I still need. For example, in Indonesia, if I'm a foreigner and I'm afraid to go to the Indonesian court because it can be maybe take long and maybe I'm not the right way to do that, then I need again my personal trust, even if there is law. And the technology now is replacing this instrument in the way that we cannot, in the ubiquity, be sure that we can enforce our legal interest by the means of the law. Because, for example, if I want to protect it in my private data, of course there is data protection law, but I know that the private data protection law cannot protect me from influence from servers outside. If the platforms outside Germany or outside European Union want to collect my data and they don't comply with the rules, what can I do? So I know European data protection law works in a certain way because they respect our market. But if I'm not sure they respect our market and they don't want to comply with our rules, I'm not sure. For example, Telegram is a messenger system. In the pandemic, Telegram, and nowadays also Telegram, is used by these conspiracy groups often because it is not controllable. Telegram spreads a lot of hate speech, spreads a lot of fake news, and so on. The owner of Telegram, as I know, is a Russian living in Dubai. So how we influence a Russian living in Dubai? The German government we have a legislation against hate speech, and so these things. The German government addressed this guy in Dubai several times, and this guy just doesn't answer to the German government. This guy is ignoring everything. So, so how we ban that? Or how we ban, for example, TikTok is an issue in the West. Yeah, TikTok spreads a lot of propaganda. That is at least and actually it's true. And how we ban TikTok? How we can ban TikTok? Yeah, so there is of course a lot of tricks. Of course you can ban Chinese companies, but what they do is to take a Singaporean CEO and put the main company in Singapore, and Singapore is not under boycott, but nevertheless, it's very difficult to ban TikTok. Even Trump was not able to ban TikTok. Yeah, the Chinese, yeah, they make a censorship, close down but then there is VPN or whatever. Yeah, difficult. So this means if the law cannot protect me, I replace it with the technology. Because technological instrument can protect me maybe. For example, I can mask my data. For example, I can have AI controlling when someone is trying to hack my computer. For example, I don't need a contract. I make this, but I said, yeah, this blockchain-based contracting, yeah, which is automatically enforced. And I don't need a human intervention anymore if there is a conflict. So we avoid conflicts by technology, or if there is a problem, we maybe handle the problem by using technology. This is what I mean with that. So it's actually two or three stages. Yeah. First, there is the original trust aspect, the individual trust. Then there's the systemic trust in the conduction of societies by the law. And the conduction of the societies by the law worked until now very good. But now we see that the law, as a sovereignty aspect of the states, territorial, is maybe not working anymore. Then we have the choice, or we apply our law extraterritorial, but someday it will not work anymore. And then we need other instruments for securing or saving our interest. And that might be in the technology. Is that more or less explaining your question? Okay.
Thank you, moderator, and thank you, Prof, for your good course material. I just want to know about your opinion in the development of legal science. In your opinion, can the technology such as artificial intelligence become a legal subject that can have legal responsible, maybe can be punished or something. Thank you.
The issue of the personification is already raised in Europe many years ago by the European Parliament, which suggested to create an electronic person. Creation of electronic person, European Union has no competence to change the civil law of the member states, so it did not have any impact to the member states. But the creation of electronic person is dogmatically not so easy. It depending first of all on the method how we make personification in general. So I mentioned that very shortly, that a natural person is a natural person, is a legal person because we are human. So this is a humanistic concept based in the human dignity. It is absolutely not possible for a legislator to decide that a human being is not a legal person, because we have dignity, and that is a pre-constitutional and actually a natural law aspect, right? But it is not clear why an association or a foundation should be a legal person. So, and there are two ways now to decide about that. Or I say, look, these bottles here, bottles are really bad treated. People drink them and then they throw them into the landscape, or they step on it, or they make something out of it. Let's make a nonsense legislator and write a law, undang-undang perlindungan botol. Ya, pasal 1, botol adalah legal person. If we follow the fiction theory of Savigny, this is a legal person now, because it is in the discretion of the legislator to just make the fiction of legal person. Of course, the legislator will not do it because there is no pragmatical reason for that. But for making a foundation a legal person is a pragmatical reason because it's useful. Yeah. This is not really my. I'm not of the opinion that this fiction theory is enough. There must be, let's say, a factual background for making a personification of something, and the factual background is seen in the reality theories and group theories of Otto von Gierke. For example, Otto von Gierke said, if a group of people decide to be a unity and decide to follow a certain purpose for the action as a group, then the law should not decide they are. The law should react to this reality of the group. This is a humanistic background of making a personification of an association or of a company, yeah, like this. Because the group is a humanistic idea which is going together and the people want to be a unit. That's why we have associations which are legal person. Now, what's with the foundation? Foundation is a little bit difficult because the foundation is just actually an amount of money or a property which is for the foundation, and there is an organ of the foundation, but the humanistic background, short said, is in the idea of the founder. The founder has an idea, they put the idea into the foundation follows that idea. This is a humanistic background, so it's a good reason to, also in the realistic theory, why we say foundation are legal person. Now, how about animals? Maybe you know the case Naruto versus Slater. Naruto is this macaque here in Sulawesi. There's a monkey. This monkey made a selfie in the forest of Sulawesi whilst the photographer was taking a coffee, and then the photographer found this photo of this monkey and he got a lot of royalties because the photo was going viral. It was a very famous photo. Then an animal protection organization in the United States, PETA, the People for the Protection of Animals Incorporation, was suing this Mr. Slater, the photographer, because they said, why Mr. Slater gets the royalties? It's the monkey making the photo. The monkey has the copyright, and we are the next friend to the monkey, so we want the money. So he sued them in the American court, and the court of Ninth Circuit in New York or wherever, I don't know. Some high American court had to decide about the legal capacity of the monkey to be owner of a copyright. And the second question was why exactly this organization is the next friend of this monkey, right? But the first question is, can the monkey ever have a copyright? And of course, they said it cannot. Is there a philosophical background for giving animal legal capacity? We can say analogy to the human being is if something can suffer or can have a desire or can have wishes, and high developed mammalia can have. So if you see the gorillas or so they or the dolphins, they have feelings. So there is a good reason if we want to protect these animals to make them a person. Now we come finally to the algorithm, to the electronic person. Where is the humanistic background to give AI legal capacity? If the humanistic background or the analogy to the humanistic background is the feeling and the flexibility of acting and reacting based on desire, then think of Mr. Sartre or Monsieur Jean-Paul Sartre, then AI cannot have a humanistic background. So if we make that, then we must make it on the basis of the fiction theory. And it is possible to say we have good pragmatic reason to make the AI a legal subject because we have certain problems otherwise to assume, to assign responsibilities to person. Yeah. For example, if the AI is creating something, who is the owner of the creation? If you click the button and the creation comes out, are you the copywriter? No, because there is no intellectual action you did. The AI did all. If you tell the AI, I want a picture with the following aspects, blah, 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 blah. This picture is not good enough. Make this like this and make like this. Then the human being makes a creation. And then we can say the AI is just a tool of the human being. We assign the responsibility for the picture or the ownership of the picture to the human being. But if the AI does all alone, and also that applies if the AI damaged someone all alone without any influence, it's very far away of the human. Then how we assign responsibilities. We can assign responsibilities with agent principles. So it's the agent of someone who is profiting from it. For example, Lufthansa use AI. The AI is independent maybe, but it is acting in favor of Lufthansa. So Lufthansa should take the responsibility. Yeah. But at some point, we will not be able to assign responsibility because the AIs will be absolutely autonomous, maybe acting, reorganizing, reprogramming, and who should have responsibility for that? In that point, we must discuss whether AI should have legal capacity, whether the self-driving car should have legal capacity. So if someone is damaged, someone must be sued, and that would be the AI. But until then is a little bit time, right? But even if we have that, the problem will be a practical because the AI has no money. So how the AI pays the damage? We need additional concepts, for example, for giving the AI a money, like to association who pays the money from the basis property of the association. For example, funds principle. So everyone who buys an AI item must pay a certain percentage into some fund, and that fund is used for the damage repairs, for example. Yeah. So this concept we cannot discuss here, but you see, just giving legal personality to AI is not enough. We must also find solutions for the practical problems if the AI is a legal person. But it depends on how we follow, which principle we follow, reality principle or fiction principle. And as I know, it's also in the Islamic law, a discussion about personifications. There's also several similar concepts. I know at least one article from Malaysia discussing that. Very interesting.
The next chance I gave to Nafil, please.
Okay, thank you for the chance. My name Nafil, sir. I'm from Civil Department. I have some question, but talking about technology digitalization, I'm focusing about artificial intelligence because for your information, I lead a research team that we are developing AI for interpretation for the law, interpretation legal. A few days ago, I read some article written by Skopova that mentioned about interesting case in Germany that Hamburg Bar Association sue a platform Smart Law because giving a illegal service by artificial intelligence. So my question, the first question is, how far is development AI regulation or the state of the art about AI regulation in Germany country? Is it AI legal to use in any practical law aspect, like in government environment maybe? And the last for opinion about the legal service is doing by AI, and is it able to use by government or civil? Maybe that's all. Thank you very much.
The legislation is coming up on the basis of the European Union, not the nationals, not the member states. So Germany will not make a particular regulation. It will be the European Union regulation, which is directly applicable to all member states of the European Union, which was politically highly problematic because some of the member states wanted to have a self-restriction of companies using AI to not disturb the development and also the position of the European market. Other countries wanted a stricter regulation. For example, France and Estlandia wanted to make a more liberal regulation or no regulation at all. The political problem was really difficult. And this is a high compromising regulation, which has a risk-based approach. This means it is assessing whether the use of AI is a non-acceptable risk, a high risk, a middle risk, or a low risk. So depending on the risk assessment, it is forbidden, absolutely forbidden, or it is allowed, but under very strong and very strict monitoring duties and compliance duties, and also reporting duties, until low risk, where the duties are not really relevant. Whether these GPT systems, which are, I suppose, also used for interpreting law, fall under low risk or middle risk or high risk is not yet clear. If GPTs, for example, large language models, for example, as general AI models, whether if they have a systemic risk, then they fall under high risk assessment, and that means it can be that there must be very, very strict rules applying here. So this is the first, this is the state of the art of the legislation in Germany. Regarding the question of the infringement of other legislation, and I didn't know the case, but I suppose Hamburg was assessing the Rechtsberatungsgesetz. This is the law for legal advice, which is actually a protection law for lawyers and law firms, and also should assure the quality of legal advice. It is not allowed by anybody just make legal advice and make money with that. Yeah. So when my students want legal advice from me, theoretically I could there is instrument or help. I could help in a certain way. There is a certain ways to do that, but I never do it because I come into conflict with that because I'm not admitted lawyer. I can do that, of course, but I don't want, because I'm not a lawyer, and actually that would be a conflict with the profession of the lawyers. Yeah, this is important, and so if anybody does that, then it's a conflict with that law. And if and the not so clear problem is, what if AI makes legal advice or assess legal issues? Yeah. Directly to consumers or directly to clients. So instead of going to the lawyer, there is an expert system, and the citizen can just ask the AI about this problem, and the AI will develop a solution for this. It's not clear, and that is, I'm sure, the case. We don't know yet, because in the moment the legislation is not yet in power. We don't know yet the relation between this AI regulation and other laws. Yeah, what is how we solve this conflict? But generally spoken, we can say that courts and lawyers use AI, and the assessment whether they can use that, you said it yourself, civil or state, is depending on whether it's from public or it's private. If in the case of lawyers, AI will replace a lot of the task of the lawyers in AI systems, expert systems, assessment, interpretation, and for certain typical cases, we already use the AI. For example, if an aircraft is delayed or the flight is cancelled, in the European passenger regulation is exactly written how much money you get back if the delay is 3 hours, 4 hours, 6 hours, and so on. That can be easily assessed by AI already and is assessed. For example, we have mass processes because of this diesel fraud. so the diesel are not clean enough, and so the people get money back from, because the courts decided there is a damage repair for that, can be assessed by AI. Lawyers can use the AI, but AI is not clear whether AI can replace the lawyer by giving legal advice to the people instead of lawyers. This is maybe a conflict with this Rechtsberatungsgesetz, so not clear. Yeah. When it comes to the use of AI by public institutions or instead of courts, I have a reservation about this. So this is also not yet clear, but it is clear that it will not be absolutely forbidden. Yeah, so AIs can be used for assess something, but in my opinion, this is also the basis of the new regulation. Basically, the fate of people should not be dependent only on the machinized or automatized decision of AIs. Yeah, so it will not be possible to, for example, decide about someone gets a loan just based on AI decision, which has the danger of bias or of stigmatizing someone. So the AI gets a lot of facts, for example, where I live, in which street in the city, and this is not a good place. So the AI assumes that guy will not pay the money back because he cannot afford a house in the more elegant place. Yeah. This is something in the AI regulation which is a limit. If these systems assess a person and the result of assessment is just based on the automatized system, then it is not conform with the regulation. This applies also to the use of AI by authorities. Authorities cannot just decide about whether you get the allowance to build a house here or there, just based on automatized decision. Yeah. If it comes to courts, I remember some years ago I was in Addis Ababa in Ethiopia, and there was a Finnish guy in a conference, and there was a Finnish guy who told me, Stefan, I'm so sorry, yeah, but you lawyers and courts will be replaced soon by AI. We in Finland already decide a lot in our university with AI. And I said, oh yeah? Yeah, because we don't need the judges anymore. And I say, why you want that? It's clear, judges are human beings. Yeah, judges make mistakes, they decide wrong, they might be a good day or a bad day. Yeah, sometimes they decide milder or sometimes too strong. And there is also the faults of the decision, right? There's AI will be much better. Same happened when you talk with IT guys, always the same. It happened in Jakarta in a conference. Some IT guy has a company making AI, said, AI is much better. Yeah, AI is much better than the judges. The judges make mistake. The judges make you corrupt. Yeah, AI is not corrupt. All true. I was a judge. It's true. In the morning and Wednesday, I had my days. I was a judge for youth criminality. I had my days in the morning. I had to do my processes in the morning. There's these oral procedures in the morning. And sometimes I was tired. Sometimes I was good mood. Sometimes bad mood. I always followed the rules of the law. I was always taking very careful not to bring my moods into the decision, but we are human beings. And sometimes we are tired and something is not, we don't get it, yeah? Or sometimes we are very mild and say, come on. You will not get 3 months, you get maybe 2 months, something like this, yeah? AI would not do that. AI would assess the case, and the AI would say, 85% the delinquent was it. There is this aspect, this aspect, this aspect, go to jail. A German judge cannot do that. Why? Because in the criminal procedure law is clearly regulated that the judge cannot sentence someone if the judge is not absolutely 100% convinced of the guilt. So even if 80% or 90% of all the proofs and the testimonies show me that most likely he was it, if I say, but there is 5% the chance he didn't do it, and I'm not absolutely convinced, I'm not allowed to sentence him. Whether the public is agree with that or not, it doesn't matter. The judge is independent. This is the right of the delinquent. First of all, this would be infringed if AI decide, because how can AI decide? AI cannot be convinced. AI can make the decision based on likeliness. And the higher the likeliness, the likeliness is that it will sentence someone. And this is exactly also the problem with the death penalty, right? So we always very fast with saying, kill 10 children, must be death penalty. In Germany, we don't have death penalty for good reason. Must be death penalty. When also Germans say it, why we don't have the death penalty? He is very clear. Yeah, sometimes it's very clear. But we also know that around 2% or more in American jails are in jail, even if they didn't do it. And we always see the case after 40 years, someone comes free, is rehabilitated because they found out after 40 years he cannot have done it. And 40 years he sit in the jail for nothing. Now imagine you kill him. So how we can ever be sure that something is like this? If we call Karl Popper, the philosopher, who said there is never a clear truth, we can only find nearness to the truth. We must falsificate, right? And then we come closer and closer. The death penalty is very problematic because the death penalty is final. And if the AI decide it's 5% likeliness and he is dead, we can never change something. So what I want to say to cut that, I want to say that it is the right of the delinquent to have the chance to be under a sentence which is milder because the judge has good mood, but also it is the risk of the delinquent to be maybe harder punished because the judge want to be home and don't want to think about it much, yeah, and want to eat his dinner. This is not nice, but is this a chance? And this is exactly the essence of being a human in a being human society. In a human society, we have the chance that we interact with human beings, which are maybe likely good for us or not so good for us. With other words, I think that replacing courts and judges especially at least in certain fields like criminal law by AI is anti-constitutional, it's unconstitutional, it's infringement of the human dignity, because human dignity means that I'm treated like a human in a human society and not like a number in a calculated and determined assessment process by AI. So I think in that sense we should not replace. Even using AI as a help for decision for the courts might be already problematic because the AI brings a certain bias. If the judge is tired and want to go home to his wife or to his woman or his man, her husband, and it's already late, and he asked the AI, and the AI said 90% he was it. I want to go home. Okay, sentence. Yeah, it's a bias danger, right? So the judge should do the decision without a bias, should do the decision free, with a free mind, open mind, and be full convinced. I think this answers more or less because the question has a very wide range, actually.
Once again, please give applause to Professor Stefan. Does anyone want to ask once more? Oh yeah, Nadia, please. Yeah.
Okay, thank you so much for the chance. My name is Nadia Khairia Kadir. I'm from International Law Department. And first of all, we're also happy to your explanation and discussion today. In International Law Department, we have a Center of Economics and Development Studies program and also a Center of Telematics and Information Studies. We hope that you can active and contribute to our center studies and will be useful for sharing knowledge. And next, my question is, what if after we're making a contract with foreigner via AI and dispute arise, how can we resolve that problem? Thank you.
First of all, in a moment, we cannot make contract with the AI. But in a moment, we can assign the responsibility for contractual acting mostly to human. Because if I apply, the qualification of smart contracts in the contract law is not that easy. The smart contract is most likely understood as the offer. The smart contract is actually not the contract. Yeah, the smart contract is actually the offer. And if the offer is controlled by AI, that does not change the qualification as a contractual offer. And who is triggering the smart contract accepts the offer. So now, if the AI is triggering the smart contract, indeed we get the problem to assign this triggering to some human in the moment, because as I said, the AI is not a legal person. So if the AI is programmed in a certain way to trigger it in my interest, then we might, because someone programmed that, and maybe I agree with my contractual partner that we program and deploy this smart contract, then we assign this action of the AI, this triggering action, to me as a legal person, and I'm accepting the contract, and we have a contract between two human contractual partners. Yeah. So this is the state of the art in the moment. In the moment, we have not really full AI contracts. It is, as I know, in the United States law, there's already a way to have electronic contracts done by AIs, but I'm not so sure. I did not make a research about that. I'm not so sure. I write something in one of the articles of AI in the ResearchGate, one older from in Unair journal in Juridica. I'm not so sure if that is really meaning that the AI is absolutely independent from a human. Normally, we say this is still assigned to a human, like the chewing gum machine. Yeah, would you say this is a machine decision, or you have a supermarket and the supermarket has a control system which knows from the factoring which products are now missing? And then the system buys automatically the products to the supermarket without a human being going and clicking here. Yeah, is that an AI contract? No, because the supermarket produced this algorithm, and the algorithm is controlled by the factoring system, and then the algorithm will just inhibit the delivery. But this is not an AI contract, because actually it's an anticipated declaration of will of the supermarket employee. So they anticipate their legal will, their contractual will into the programming. And the same happens with mostly nowadays still with this smart contract connected with AI. But and that means the enforcement is the same. A part of it is a smart contract, then we don't need this enforcement because it is automatically executed. The problem, as I said, the conflict will arise later in the question when it is not correctly programmed. So it does not exactly what the people wanted. This means someone programmed the smart contract and they programmed it wrong. So we will have a shift to the product responsibility of the smart contract, less to the enforcement. But if really two future AI entities collaborate and co-act, of course, someone must make the arbitration about this. Yeah, it might be assessed automatically in this case. Yeah, or by courts. But this is what I mean with disruption. Yeah, for example, flexibility principles. Your colleague said about the system interpreting legal rules and interpreting the law or something like this. I already wrote in my first article about the AI that is in the moment still very problematic, because the law is not just applying the sentence of the legal rule. Yeah, the court cannot just say, okay, in the legal rule there is the fact and there's the fact and there's the fact and we add it and then this is like this. This is subsummation. The subsummation can work like that, but very often the subsummation and the decision that is in the letters of the law, it's like this, will not work. Yeah, we have the bona fides principle, we have the general clauses, we have the trust clause, yeah. So also we have the cessation of the contractual basis. So even if there's a contract and the contract is very clear, interpretable by the AI, by the letters of the contract, we must say, okay, but the condition of the contract changed totally. What you do in the pandemic, you have a renting of a shop. And in the pandemic, you must close the shop for 3 years. Do you have to pay the rent? Yeah, or should we adapt the contract? And this depending not only on the letters of the law, it depending also on assessment, for example, of who should take the risk of an incident which was not foreseeable, the black swan. Yeah, who should take the risk of the pandemic? Is it the owner of the shop? Or is it the one who hires the shop? Then he must pay, even if the pandemic. Or is the owner of the shop taking the risk of the pandemic? Then he doesn't get the money for the 3 years. Or is it the society, because we have maybe a collective responsibility or collective fairness principle that the society should maybe take the risk for that, at least partly. Then the government will maybe pay a damage repair to both. That happened in Germany, for example, with the kindergarten. I could not send my child to the kindergarten for a long time because it was closed, but I had to pay €398 per month for this kindergarten. Yeah. If I say my child cannot go to the kindergarten, I will not pay anything. Then the risk is on the kindergarten. If I say, I will get the money, no, the risk is on me. Sorry. If I say my child doesn't go, and I don't pay here, or I pay, nevertheless I must pay that, then the risk is on me, and otherwise it's the risk on the kindergarten because they don't get money. Or what happened in Bavaria, the Bavarian state said, actually, we must take the responsibility because it's a solidarity principle in this pandemic. This is not the risk of just one part or one part. This is a pandemic, is a what do you say? It's a solidaric risk, right? Then we reimburse the parents for at least 2 of the 4 months, and I got the money for 2 months back, and the kindergarten got the money, and I got the half of the money back. So the risk is shared with the society because, of course, this is paid by the state money, by the tax money. Yeah. So this is the question how we assess risks and how we give the risk to some part or the society, and how you want the AI assessing that risks. This is highly dependent also on the feelings of the society, on cultural aspects, on fairness aspects, and these are flexible concepts which cannot be assessed so easy by algorithms. So that's why I'm very reluctant to accept that we have a law which is just analyzed by algorithms, and the algorithm interprets the law. We need human judges to interpret law, because interpretation or application of law is just more than apply the wording of the law. Yeah, it's fairness. That answering more or less?
Yeah, thank you, Prof, for very interesting answer. Due to limited time, I had to end this session. Finally, as the moderator, apologize if there is mistakes. Thank you for your attention, especially Professor Stefan Koos, who gave a very nice presentation. Good afternoon. I return to Bu Fadila.
Thank you so much, Dr. Kadarudin, for leading these sessions. Please give a round of applause for our moderator and also for our presenter, Dr. Stefan Koos, Professor Stefan Koos. Okay, so now I would like to invite our Dean, Professor Dr. Hamzah Halim, to give a token of appreciations to our speaker today, Professor Stefan Koos. So, Professor Hamzah Halim, please come forward.
Hello.
Now we will conduct group pictures. So everyone, oh. So all the participants, we would like to invite you to come forward to take the group pictures. Yeah. Oh, okay. Ah, Kak, kayaknya mau di. Oh, iya. So we'll do two group pictures first. We would like to invite everyone to come to the front. For all the students, please take place nearby the chair.
Atau di bawah sini yang balik. Oh,
Everyone, please look at the camera. For the second picture, please everybody take your seat back. Please di sini, silahkan duduk teman-teman. Nanti kita ambil foto kedua.
Sorry ya, saya perlu foto untuk sedikit ya.
Ya.
Kasih administrasi pada untuk ya mereka ya memang harus saya kerja.
Okay. Yeah, everyone, please be seated, and we will take the next group picture. Yeah. Yeah. Please stand up, everyone, and move closer to the middle.
kasih kelihatan tulisan untuk.
Thank you everyone for your participations on this Stadium Generale. That's all for today's event. Thank you so much for your participations, both for the participants via Zoom and those who directly came to the Moot Court Harifin Tumpa. That's all for today. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.